Mr. President, I'm honored to join my distinguished colleague from New Jersey here today on the Senate floor to speak in support of the confirmation of Judge Sotomayor as the next Associate Justice of the United States Supreme Court. I had the privilege to sit on the Judiciary Committee for her confirmation hearing, and I join all of my committee colleagues on both sides of the aisle who have complimented Chairman Leahy for a very well-run hearing. I was proud to vote for Judge Sotomayor in the Judiciary Committee, and I will be proud to vote for her confirmation here on the Senate floor. Judge Sotomayor's remarkable education and professional qualifications, her commitment to public service, her uncontroversial 17-year record on the federal bench, longer than any nominee in 100 years, her responsiveness and patient judicial temperament at the hearing, all confirm to me her pledge that she will respect the role of Congress as representatives of the American people, that she will decide cases based on the law and the facts before her, that she will not prejudge any case but listen to every party that comes before her, and that she will respect precedent and limit herself to the issues that the court must decide. In short, that she will use the broad discretion of a Supreme Court justice wisely. I applaud those of my colleagues who have acknowledged that Judge Sotomayor falls well within the mainstream of the American legal profession. At the same time, it is disappointing that so few Republican colleagues have been willing to recognize her clear qualifications for our highest court. The nearly unanimous party line opposition offered by Republicans in committee and here on the floor raises serious concerns whether some of my colleagues would ever be willing to vote for anyone outside of the Federalist Society. To my Republican colleagues in opposition, I would ask, what Democratic nominee would you vote for if not Judge Sotomayor? With her vast experience, her commitment to the rule of law, proven indisputably over 17 years, her remarkable credentials, and her extraordinary, moving American life story. Unfortunately, Judge Sotomayor seems to be walking proof that conservative political orthodoxy is now their confirmation test, masked as concerns about judicial activism. Many of my Republican colleagues unfairly ignore her long record to base criticisms on strained interpretations of a few routine and appropriate circuit court opinions and a few remarks taken out of context. Those criticisms feel, quite frankly, like the criticisms of someone who is determined to find fault with a nominee. Take, for example, the New Haven firefighters case. The per curiam opinion in Ritchie was based on controlling Second Circuit and Supreme Court precedent. The Sixth Circuit took the same approach in a similar case arising in Memphis. The role of a circuit court is to follow existing precedents of the Supreme Court and the Circuit Court. That is what the Ritchie per curiam did. The Supreme Court may have reversed, but it did so 5-4 on the basis of an entirely new test it created. It is absurd to call Judge Sotomayor an activist for following existing precedent. If you want a judicially conservative opinion, the Ritchie per curiam is just that. The decision in Maloney was also properly conservative in a judicial sense. It approaches with caution a newly minted and narrowly enacted constitutional right, whose extension to the states would upset generations of practice and experience by sovereign states regulating guns within their borders. A Seventh Circuit panel with two very prominent conservative judges on it correctly did exactly the same thing. A Ninth Circuit panel reached a different conclusion, and then that decision was vacated by the circuit to reconsider that case en banc. Rather than engaging in a serious inquiry into Judge Sotomayor's fitness for the Supreme Court, many of my Republican colleagues have made this nomination into a referendum on whether the newly minted individual right to bear arms should be incorporated against the states for for the first time in our nation's history. This is doubly unfair. First, Judge Sotomayor could not answer questions at her hearing that would suggest how she would rule in later cases. That is inappropriate. Second, it is inappropriate to try to force on a judge a particular political view as the price of admission to her judicial office. Criticisms of a few stray lines in Judge Sotomayor's various speeches are equally perplexing. Judge Sotomayor's long and non-controversial 17-year judicial record should allay any concerns about those remarks. But so should the context of those speeches themselves. The wise Latina comment we've heard so much about came in a speech that argued how important it is for judges to guard against bias and to be aware of their own prejudices. Is it not better and truer to admit that we all have prejudices we must manage than to pretend that white males form some sort of ideal cultural baseline that has no biases? Senator Specter said it well at the committee vote. There is nothing wrong with a little ethnic pride and a desire to encourage her law student audience. Maybe we should try to put ourselves in their shoes. Perhaps with a little empathy ourselves, it might be easier to understand how a profession and a judiciary dominated by white males might look to those young law students, and how important a little encouragement to them might be that their experiences might give them something valuable to contribute, that they're not the exception, that they are welcome and fully a part of our society, and that they bring something valuable not only to the profession, but one day perhaps even to the judiciary. In sum, my Republican colleagues' criticisms of Judge Sotomayor appear to be grounded in conservative political ideology rather than legitimate concern that Judge Sotomayor is not fit to serve on the Supreme Court, grounded in a desire for more of the right-wing justices who in recent years have filled out a conservative wing on the Supreme Court. That wing has marched the court deliberately to the right in the last few years, completely discrediting the Republican claim that judges are mere umpires. Jeffrey Toobin is a well-respected legal commentator, particularly focusing on the Supreme Court. He's recently reported, and I quote, "In every major case since he became the nation's 17th Chief Justice, Roberts has sided with the prosecution over the defendant, the state over the condemned, the executive branch over the legislative, and the corporate defendant over the individual plaintiff. In every major case, some umpire." And is it a coincidence that this pattern, to continue Toobin's quote, has served the interests and reflected the values of the contemporary Republican Party? Some coincidence. The phrase liberal judicial activism is now conservative speak for any outcome the far right dislikes. They did not use it when the conservative bloc of the court announced, by the barest of 5-4 margins, an individual right to bear arms that had gone unnoticed by the Supreme Court for the first 220 years of its history. If that's not an activist decision, the term has no meaning. It's just activism that conforms with a deliberate Republican strategy of many years' duration to pack onto America's courts proven conservative judges who will deliver the political goods they seek. Setting aside all this politics, we should also never forget, never overlook the historic role that judges play in protecting the less powerful among us. And we should always appreciate how a real-world understanding of the real-life impact of judicial decisions is a proper and necessary part of the process of judging. Judge Sotomayor's wide experience, I hope, will bring her a sense of the difficult circumstances faced by the less powerful among us. The woman on the phone, shunted around the bank from voicemail to voicemail for hours as she tries to find someone to help her avoid foreclosure for her home. The family struggling to get by in the neighborhood where the police only come with raid jackets on. The couple up late at night at the kitchen table after the kids are in bed, sweating out how to make ends meet that month. Or the man who believes a little differently, or looks a little different, or thinks things should be different. If Justice Sotomayor's wide experience gives her empathy for those people so that she gives them a full and fair hearing and seeks to understand the real-world impact of her decisions on them, she will be doing nothing wrong. Nothing wrong by the measure of history, nothing wrong by the measure of justice. Experience, judgment, wise use of discretion, and a willingness to stand up against oppression have always been the historic hallmarks of a great judge. Experience. Justice Oliver Wendell Holmes famously explained, "The life of the law has not been logic, it has been experience." Experience. The felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men, have had a good deal more to do than the syllogism in determining the rules by which men should be governed. As Justice Holmes continued, the law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if it contained only the axioms and corollaries of a book of mathematics. Experience. Judgment. Just as John Paul Stevens has observed, the work of federal judges from the days of John Marshall to the present, like the work of the English common law judges, sometimes requires the exercise of judgment, a faculty that inevitably calls into play notions of justice, fairness, and concern about the future impact of a decision. Wise use of discretion. Justice Benjamin Cardozo wrote, "The judge, even when he is free, is still not wholly free. He is not to innovate at pleasure. He is not a knight-errant roaming at will in pursuit of his own ideal of beauty or of goodness. He is to draw his inspiration from consecrated principles. He is not to yield to spasmodic sentiment, to vague and unregulated benevolence. He is to exercise a discretion informed by tradition, methodized by analogy, disciplined by system, and subordinated to the primordial necessity of order in the social life. Wide enough," Justice Cardozo concludes, "in all conscience is the field of discretion that remains." And as Alexander Hamilton explained in the Federalist Papers, courts were designed to be our guardians against what he called those ill humors which the arts of designing men or the influence of particular conjunctures sometimes disseminate among the people, and which have a tendency to occasion serious oppressions of the minor party in the community. Nowadays, those oppressions tend to fall on the poor and the voiceless, but as Hamilton noted, to continue his quote, "Considerate men of every description ought to prize whatever will tend to beget or fortify that temper in the courts, as no man can be sure that he may not be tomorrow the victim of a spirit of injustice by which he may be a gainer today." We should not discard the wisdom of centuries. Experience, judgment, wise use of discretion, and protection from oppression. The standard for judges of Alexander Hamilton, of Justice Holmes, Justice Cardozo, and Justice Stevens. History stands with them. And thoughtful people will note that empathy is a common thread through each of those characteristics. Why might empathy matter? Why might it make a difference? Well, let's go back in history and take, for example, the history of the Colfax Massacre. Go back to Sunday, April 13th, 1873, when a gang of white men murdered more than 60 black freedmen in Colfax, Louisiana. Some were burned in a courthouse where they had taken refuge. Others were shot as they fled the burning courthouse. Others were taken prisoner and later that day executed. United States Attorney James Roswell Beckwith determined to prosecute white citizens involved in the Colfax massacre. Not a popular call in those days. The case was tried before a United States District Judge, William B. Woods, who determined that rule of law should prevail in his district. Predictably, polite white society was outraged. And it took notable human empathy in that place and time to see the massacre of the black freedmen as a crime, and to contemplate trying white men for the murder of black men. The case was brought as one of the first applications of the Federal Enforcement Act, implementing the Constitution's brand new 14th Amendment. So there was wide room for judicial discretion in that uncharted area of law. No balls and strikes, no phony umpires here. District Judge Woods assured a fair trial, but he was also prepared to honor Congress's desire that outrages upon the black community should be punished as crime. He had sufficient empathy with the widows and the children of the slain freedmen to take seriously their need for vindication. And he had sufficient courage to face the scorn and anger of the white community. Another judge was involved. United States Supreme Court Justice Joseph P. Bradley, who under the procedural rules of the time rode circuit for Louisiana and could sit in on trials. And sit in he did. He had no sympathy for the former slaves and little regard for Congress's intent to punish the abuse of freedmen. Disagreeing from the trial court bench with Judge Woods, Justice Bradley found repeated technical faults with the indictments, took a restricted view of the authorities of the 14th Amendment, dismissed the charges, and released the defendants to flee on low bail pending an appeal. The United States Supreme Court upheld its colleague Bradley's opinions, thereby gutting the 14th Amendment and the Enforcement Act for a generation. And thereupon, a wave of murder and violence by Klansmen and White League members, emboldened by de facto immunity from prosecution, swept the South. Reconstruction was vitiated in those weeks. Justice for the murder of a black man by a white departed the South for nearly a century. History and the law both ultimately proved District Court Judge Woods correct. But how much turned on the character of two judges? One who had the empathy to see black men as victims of crime and the courage to outrage white opinion by allowing the trial of white community leaders before a mixed jury, no less. The other, a judge who valued the status quo and recoiled from any shock to proper white opinion and authority, indeed, who was the reflection of that proper opinion. That is what we mean by empathy. And while the divisions in our society are less today, there are still people who feel voiceless, whose voices a judge must be attuned to hear. There are still Americans who come to court bearing disadvantages that have nothing to do with the merits of their case. Empathy, to look through those disadvantages, to see the real merits of the case, even when it is unpopular or offends the power structure, is the hallmark of a great judge. The words of Hamilton, Holmes, Cardozo, and Stevens that I have quoted display that as history. The contrasting approaches of the two judges after the Colfax massacre display it as justice. My Republican colleagues' misunderstanding of judicial history has led today to a missed opportunity for bipartisan support of a highly qualified and moderate judge who falls well within the mainstream of American legal thought. We could be celebrating the first Latina justice of the Supreme Court as a great and common bipartisan American achievement. Instead, here we are on the floor having to defend basic principles of American history from assault from the right. I hope that, as the future looks back on this day, it will be the historic nature of this nomination that will be remembered, not the strange and strained efforts to impose right-wing political orthodoxy on the courts that defend our constitutional rights. I look forward to Judge Sotomayor's service as an excellent and historic Supreme Court justice. I will vote proudly for her confirmation.